Filing a patent application isn't the end of the journey. You step onto a battlefield where your invention can be attacked, challenged, and destroyed. The textbook version of inventing sounds like a straight line. You get an idea, do a quick prior art search, and draft an application. In reality, that paperwork is just the first step into a complex legal landscape. The most critical part of that paperwork is the section called the claims. These specific sentences define the exact legal borders of your invention. Everything inside those borders is the territory you will have to defend. Lock in your priority date via Path A for developing ideas, or Path B. Notice the yellow warning box. Path A triggers a strict 12-month window. If missed by day 366, the application is abandoned and priority is permanently lost. Assuming you meet that deadline, your application enters an 18-month slumber. It sits at the patent office until it is automatically published in the official patent journal. Publication makes the details of your invention accessible to everyone. The world can now see what you are trying to claim, and the first wave of challenges can begin. The first wave of attacks comes from the general public. Indian patent law specifically empowers citizens to act as a check against inventions that lack novelty or are wrongfully obtained. This infographic breaks down pre-grant opposition. Under Who Can File, notice it states any person. Under Official Fee, it costs 0 rupees. The Outcome panel shows the stakes. The controller can force claim amendments or refuse the patent entirely. Even if the public ignores your application, the Indian Patent Office will not. The state forms the second front. This graphic illustrates the request for examination pipeline. Examination is not automatic in India. Notice the break in the timeline at month 31. For new filings, you must actively request examination before that 31-month mark, or your application dies right there. Once examined, the state issues a first examination report. The examiner dissects your claims, searching for prior art or formal errors. You must then defend your borders, amend your claims, or face immediate refusal. Surviving the public's opposition and convincing the examiner results in the grant. But this certificate marks the start of more direct commercial legal combat. Receiving the patent certificate creates a sense of security, but the asset remains exposed to those with the most to lose, your rivals. The day your grant is published, the third front opens, the competitor. Under Section 25(2) of the Patents Act, the post-grant opposition window begins ticking. Unlike the pre-grant phase, this window lasts for exactly 1 year and is strictly limited to persons interested, typically your direct market competitors. This is a highly coordinated, evidence-backed assault. Competitors submit detailed prior art and technical arguments to a specialized opposition board, which has the power to maintain, amend, or completely revoke your patent. The first 365 days of a granted patent's life are its most vulnerable. Competitors will actively try to legally remove the asset before you can use it to dominate the market. Even if a patent survives its first year, it remains exposed. Under Section 64, any person can petition the High Court to have the patent revoked entirely. These proceedings take place in the High Court and can be triggered on severe grounds. For example, if it is discovered that the invention relied on undisclosed traditional knowledge from an indigenous community, the patent can be targeted for revocation. In the case of McLeod's versus Beringer, the Delhi High Court clarified that this threat never truly ends. A revocation petition can be filed and sustained even after the patent has expired. If a court finds the patent invalid, it strips the rights away retroactively. It is treated as if the patent never existed, nullifying any infringement damages the patentee intended to collect for past use. Holding a patent requires constant, aggressive defense against the public, the state, and competitors. Without that vigilance, the asset's legal value can evaporate in a single court hearing. Don't just learn how to file, learn how to defend and attack, because that is where the real game is played. Subscribe to join the ranks of those who know how to protect their ideas.